In this second video, I will attempt to explain the DMV hearing issues to you before you receive the packet in the mail. Again, I'll use my robot friends because the law changes frequently. With a typical first-time arrest for driving under the influence of alcohol, the Department of Motor Vehicles will attempt to prove three things. First, that you were driving a vehicle that was lawfully stopped or involved in a traffic collision while you were driving. Second, that a peace officer lawfully arrested you. And third, the results of a chemical test taken within 3 hours of driving showed that your blood alcohol level was 0.08% or higher. When the cops stop you, they can easily prove who was driving the vehicle in the first element. However, when there is a collision involved, the most common way that the police prove you were driving the car is by the words you say to them on the roadside. Most people admit they were the driver, so don't worry if you told the cops you were driving. Second, the department must prove that you were lawfully arrested. They will review the police reports and assume that everything in the reports is accurate and true. This element typically only wins a few DMV hearings. Simply put, the DMV doesn't have to prove all that much to show that your arrest was lawful. Third, the DMV must prove your blood alcohol level was 0.08% or higher at the time of driving. The DMV can confirm this if you gave a chemical test within 3 hours of when you drove. Successful defenses usually involve a test administered before your arrest, which doesn't qualify in the DMV hearing, or a test administered more than 3 hours after you stopped driving. If you were on probation for DUI at the time of your arrest, then the DMV only has to prove that you had a 0.01% blood alcohol level while driving a motor vehicle. The second type of DMV hearing involves someone who refuses to provide a breath or blood alcohol sample after being arrested. The DMV has to prove three things for these hearings. The first two are the same, but the third is different. In addition to proving that you were driving and lawfully arrested, the DMV must also prove that you were advised of your requirement to provide a breath or blood sample after your arrest. The police officer must have notified you correctly that if you did not give a breath or blood sample, your driver's license would be suspended for 1 year for a first-time DUI, or longer if you've had a prior conviction. Many officers don't read the advisement off of the DS-367 form as required by law. When they do not correctly read the advisement, then we should win your hearing and you get your driver's license back. Finally, the DMV occasionally will take a separate action on your driver's license when only drugs were involved instead of alcohol. David calls it the sore loser hearing, because the cops are mad that they didn't catch you with alcohol in your blood. When this occurs, you must obtain a medical doctor's clearance before they reissue a driver's license.
Additional videos will soon be sent to you. If you have further questions, please call the office. I hope that I will be able to explain most of the process of a driving under the influence arrest and court case through the use of these videos. The best part of the videos is that you can re-watch them. I'm David Lear, founder of StrongestDefense.com. Thanks for watching.